We will go on the record in the matter 25 CF 22, State of Wisconsin versus Michael Den. The state appears through Assistant District Attorney Holly Rockow in person. We have Glenn Keene, defense.
From the very first gavel strike, the courtroom transforms into a stage where freedom, reputation, and sometimes even a lifetime hang in the balance. And here, with Michael Den, we're diving straight into a case that mixes meth, millions in potential penalties, and one massive gamble, waiving his right to a preliminary hearing. Risky move. Let's find out.
Counsel appearing by video conferencing. We have Michael Den also appearing by video in custody in Burnett County Jail. We're set here today in the matter for an initial appearance. Mr. Keene, were you able to go over the criminal complaint with Mr. Den?
Yes, Your Honor. Reviewed the charges, ranges of potential penalties. Mr. Den would waive reading, plead not guilty to the misdemeanor, and ask to have an arraignment. Oh, we're also going to ask for a bond reduction motion at some point in the near future, but I have not yet filed that.
Okay, sounds good. So he's entitled to a preliminary hearing. Is he asking for that within time limits?
Your Honor, Mr. Den is going to waive the preliminary hearing.
Oh, he wishes to waive it outright?
Yes.
And does he wish to do that now and then set the matter for a bond modification hearing in short course?
Yes, Your Honor.
Okay. So, Mr. Den, did your attorney go over with you what it is to have a preliminary hearing, and that is the hearing where the state has to prove a felony was probably committed and probably committed by you?
Quick crash course. A preliminary hearing is like a legal filter. It weeds out weak cases early. By waiving it, Den essentially says, yep, the state's case is strong enough. Let's skip straight to trial. But why would anyone give up their first chance at defense? Strategy, pressure, or maybe confidence he can beat the bigger battle ahead?
Yes.
And do you understand that by waiving your right to a preliminary hearing, you agree that at least the state can meet that burden?
Yes.
Do you understand at a preliminary hearing, your attorney would be able to ask questions of the state's witnesses or call witnesses to testify for you? Your attorney would be able to produce evidence on your behalf or possibly discover things about the case, which could include defenses, but you're giving up those rights today.
Yes.
Do you understand that if at that preliminary hearing, the state does not meet its burden as to the felonies, I could amend them to misdemeanors or I could dismiss them altogether, but you're giving up that right today?
Yes.
Do you understand that as a result of waiving your right to a preliminary hearing, that means that this matter will be bound over to future proceedings, which could include a trial?
Yes.
You understand that once you give up the right, it is forever and you cannot get it back?
Yes.
Has anyone made any threats or any promises to you for you to waive your right to a preliminary hearing?
No.
You're doing so freely and intelligently. That means you're telling me you fully understand what you're doing?
Yes.
And voluntarily?
Yes.
I will find that you are competent, you're freely, intelligently, and voluntarily waiving your right to a preliminary hearing. I find probable cause and find the matter over. Does he wish to proceed with an arraignment, Mr. Keene?
Yes, Your Honor.
Understands all the charges and the maximum penalties?
Yes, Your Honor.
And he waives formal reading?
Yes, Your Honor.
Address still on County Road M?
Yes.
Telephone ends in 0326?
No, I don't have one.
Okay, now let's go ahead and look at when we can schedule a bond modification hearing. I'm going to presume you're going to get that filed in short course.
Yes, Your Honor.
Ms. Rockow, your week or Mr. Schmidt's week?
Mr. Schmidt's.
Well, unfortunately, it has to fall on your week, and he's going to have to.
That's fine.
Fill in, because otherwise it's not going to. We won't be able to have it until probably March 27th, and that's not good. Okay, so we can set it for March 4th at 2:15. March 4th at 2:15. Does that work for your calendar, Mr. Keene?
Yes, Your Honor, because I'm there anyway that afternoon.
Oh, that's right, you are. So March 4th at 2:15. Okay, we'll see you then.
Take care.
Thank you. On the record, this is Mr. Den. What are you looking for?
Oh, sorry, there was just a bunch of others.
We will go on the record in the matter 25 CF 22, State of Wisconsin versus Michael Den. The state appears through District Attorney Kevin Schmidt in person. We have Glenn Keene appearing in person. Mr. Den appears by video conferencing in custody in Burnett County Jail. We're set here today for a request for a bond modification. Mr. Keene has filed a bond modification request on February 25th. Mr. Keene, please provide argument for the record.
Yes, Your Honor. As the court's well aware, before trial, there's a presumption that a defendant has a right to be out, not in custody and preemptively punished unless there's reason to believe that the defendant will not show up for court.
It's not necessarily true, and the state just has to prove that there's probable cause to believe that the crime was actually committed in order for the court to assess bail and to use other certain factors. It's not just making assurances that they're coming to court.
Well, right, and the other one is usually about not committing further crimes. But what I would note with Mr. Den is that he does have a record of making his prior court appearances on a lower amount of bond. He is a landowner in Burnett County. His daughter and grandson live in Burnett County. In fact, he was with them the day before he was arrested. He communicated with the court in the last case in this county in 24 FO 76. And when his other case in this county, it was more recently in 18 CF 54, he successfully appeared for all 15 court appearances and completed 9 months of jail via electronic monitoring, which obviously if you're on electronic monitoring, you can always on your own choose. It's easier to try and escape by just cutting the bracelet or other things versus if you're in the Burnett County Jail here, whereas in this issue of appearing, he's been in custody for, a month and a half, pretty much, is not being able to raise the $100,000 bond. And the only reason he didn't qualify for a public defender is because he did have, some property in the county. And we're requesting to lower bond.
And here comes the defense's classic play, painting Den as the responsible family man, a landowner, a grandfather, a guy who always shows up to court. But let's be real, judges have heard this song before. Owning property doesn't erase nearly 100 grams of meth allegedly found in your possession. Question for you, if you were the judge, would you buy this argument?
To $5,000 secured by his property, and I do have a copy of the deed that I could file with the court to show.
It would have to be a quitclaim deed signed over to the county.
Right, and we would do what we need to do to make that happen if it's granted. But and in my motion, I do show that the only thing he's showing is owing on it is $325.55 of property taxes for the current year. But the properties are valued at $33,000 because they're together $33,400 for as far as property tax valuation.
Mr. Schmidt?
I would oppose modifying bond at all. I'm deeply concerned that if Michael Den's bail is reduced any amount, he might be able to get somebody with a lot of money to post it for him, somebody powerful he knows through his connections or his family. He's charged with a delivery, which was a controlled buy, so that's a strong evidence, and he was found with nearly 100 grams of methamphetamine. The evidence is strong in the case. The strength of the evidence is something the court considers in determining bond because that's mandated by statute. He admitted to law enforcement that he was acquiring methamphetamine in the quantities of, in his description, pounds and kilos and bringing them to Burnett County and distributing them. He said his connections are in the cities, which is where his main connection is from. He only came here from Minnesota in around 10 years ago, and he's been at that property he's describing. with his admissions and what he has there, that's strong evidence. In his interview with Deputy Mogen, he expressed fear that he was going to die in custody because of these charges, which is more concern for the court that he might not come in the future. It is true that he has generally made court appearances on bond, both here in Minnesota. He has not necessarily followed probation conditions. The 2018 case we had in Burnett County, for example, was while he was on probation for felon in possession of firearm out of Minnesota. He has some familiarity with the sentencing on these charges, not just from the maximum penalty. Mr. Den's twice been convicted before for crimes related to the sale of drugs. The first time he only got a year in Minnesota. The second time he got a 10-year sentence. I think he rightly fears that he might get more than 10 years, and with his age, that could wind up basically being his whole life. I think with the strength of the evidence, with his history, with his demographic information, I think the court shouldn't reduce bond. If he gets out, I don't think he's coming back. Thank you.
All right, thank you. With hearing those facts, and the court does have to weigh into whether or not the state has proven, I believe it's even.
Boom. The prosecution is not holding back painting Den as a career dealer with connections, kilos, and a real motive to run. And let's not miss the subtext. They're basically saying, this man has nothing to lose, and that makes him dangerous. That's the kind of argument that slams the cell door shut before trial even begins.
Beyond a probable cause. But in hearing the evidence, and even in hearing the evidence that was presented in the criminal complaint, we're dealing with the delivery of methamphetamine allegation, which carries a maximum penalty of up to 12.5 years of incarceration and up to a $25,000 fine, and possession with intent to deliver methamphetamine greater than 50 grams, which is a Class C felony, which has a maximum possible penalty of up to 40 years of incarceration and up to $100,000 in bond. So that is very significant, and that is a high incentive for an individual to flee or to not make court appearances. It's not a low-level crime like a simple possession of methamphetamine, which is a maximum of 3.5 years of incarceration. Based on the arguments made, the court will deny the modification of bond.
The only thing I note on there is that D.A. Schmidt was referring to items that aren't in the complaint at all about interviews and other things.
And you can do that
right,
in a bond
fine.
hearing. You're allowed to use hearsay in a bond hearing. If you wanted to have other witnesses, you could have witnesses
right
in a bond hearing. We could have a bond modification hearing that goes 4 hours. Some states do that. Some states actually call people and put them under oath and have witnesses back and forth between the parties. Here in Wisconsin, you're allowed to use hearsay. You're allowed to make your arguments, and it would include providing information that's not in the criminal complaint.
All right. Well, like I said, I think when you look at it, you do have to at least consider his past performance as far as court appearances.
I did, but
right.
that's low-end felonies to maximum of 40 years of incarceration is what he's facing for one, maximum of 12.5 for another, and then 3.5 for the maintained drug trafficking place.
Right.
Those are two very serious felonies, one serious because it's a felony. So the court denies bond modification.
All right. I've also been, Mr. Den wishes to invoke his right to a speedy trial as well, and I've filed the motion for discovery from the DA's office.
All right, so speedy, put it in writing, but we can get a trial date set. Mr. Schmidt, how many days do you think we're going to need?
Honestly, probably one.
Only 1 day?
It was one controlled by and then searching, playing his interview, no, 2 days.
All right. Do you have lab analyst?
Not yet.
Oh, so we have to set it, and then it is a speedy, so we just okay, we'll go that route because we have to set it, and then the state has to talk to the lab to make sure that they're going to get everything ran and that we can be a number one because it is a speedy and it will go. So 90 days.
And does look like they sent it to Wausau soon after they acquired it. Police, I mean.
June 2nd and 3rd. It's a speedy, so no matter what you have, Mr. Keen, you must move it. So June 2nd and 3rd, we're setting it for a speedy trial for Mr. Den. Now let's get a final pretrial. Final pretrial, the court's drop dead date, where the court will not accept any agreement after that date and time. May 8th at 9. All right, May 7th at 2:30. May 7th at 2:30 will be the final pretrial. Again, that is the court's drop dead date. Hopefully, we're going to be able to use the 2 days that we have set aside now for our speedy trial. The court's drop dead date means the court will not accept any offer, any agreement after that date and time. That means it will go to jury, and it will go to jury on the Class F, Class C, Class I felonies, and the Class U misdemeanor. The only way it will be removed from the calendar is if we get full pleas on all or dismissals. All right. Anything further, Mr. Schmidt?
Not for me.
Mr. Keen?
No, Your Honor, thank you.
All right, then we
Can I
are,
ask something?
Oh,
no, you have to,
And just like that, game over for Den's bond request. No bail, no freedom, and the countdown to a speedy trial begins. He's staring down the barrel of decades in prison. The stakes, sky high. The question, can the defense pull off a miracle? Or is Den headed exactly where the prosecution predicts? Stick around, because this legal battle is only heating up.